Hello, students. Welcome to Module 3 in the Contracts course. By now, you should have completed the assignments for Modules 1 and 2. If you haven't, send me an email and we'll make arrangements for you to get caught up. In Module 3, we are going to be looking at offer and acceptance. Your reading assignment is to look in the Uniform Commercial Code at the provisions on offer and acceptance, which are 2-201 and 2-210. And then please read in the Restatement of Contracts, Chapter 3 on Making Offers. So you have 3 assignments for this week. The first is a written assignment asking you to prepare an IRAC and a memorandum due Sunday. And we also have a discussion forum this week on legal ethics. Your first post is due Tuesday. Your reply post is due Saturday. This week, we are going to have our first quiz. It's multiple choice, and it's cumulative of everything we've discussed. It will be due Sunday, October 24th at 11:59 p.m. Central Standard Time. To help you review for the quiz, we are going to have a live session and a quiz review on Wednesday at 6 p.m. Central Standard Time. Please make every effort to attend this quiz review by joining me at WebEx using the following link. Let's talk a little bit more about your assignments. So your written assignment this week is going to ask you to analyze issues related to the common law of contracts. In our scenario, due to a couple of new clients, your firm wants to update its research notes on offer and acceptance that are kept in electronic folders. So you have a couple of new clients who have contracts issues, and everyone in the firm wants to be updated on the recent law of offer and acceptance. So you're going to need to provide a research memoranda with references and Blue Book citations. First, you'll need to do some research on either Lexis Advance or Fastcase to find a very recent case in the area of offer and acceptance. And then use IRAC to summarize the case, meaning that you'll be discussing the issue, the rule that the court announced, the application of the rule to the facts, and discuss the conclusion that the court reached in the case. And then second, find a recent article or a blog on the internet. You can just Google the topic of offer and acceptance and summarize and cite what you find in the article. Third, decide which of the sources helped you the most in comprehending and understanding the law of offer and acceptance. 4, find and cite a portion of the UCC or the restatement that discusses offer and acceptance. Use Blue Book citations just below each of the sources in the article or blog. All the uncited portions of the paper need to be your own personal words and analysis. Let's talk about our Module 3 discussion forum because your first post is due Tuesday. Use ABA Model Rules 1-8 and 4.3. Research your home state's version of the model rules, as well as your state's attorney's professional responsibility code, because this Module 3 discussion is all about legal ethics. We're going to talk about handling an unrepresented party. I always recommend that parties to litigation or to contracts hire an attorney, but some people would like to represent themselves in contract transactions. I've seen this happen before. So in our scenario, Joe is your supervising attorney. Joe wants you and the others in the office to discuss a contract before she agrees to it based on those 2 ethical rules, 1.8 and 4.3. So in our scenario, Harry, Joe, and Dean are cousins. They're making an agreement to buy the boat. Joe will help finance the boat by offering a loan for 20% of the price of the boat. In return for the promissory note, she will get a security interest in the boat. Harry and Dean have the rest of the money in cash. Harry and Dean are going to use the boat at different times. Harry will pay the legal bill to Joe for drafting the contract. Harry and Dean want it in writing in case one of them dies, so Joe will do a buyout provision. But Dean does not want to have a separate lawyer review it. So Dean is the unrepresented party. So you want to meet with your attorney and discuss Joe's options in learning how to um, handle this unrepresented party and considering whether it's even ethical for Joe to participate in this agreement to purchase the boat. So let's take a look at the model rules. ABA 4-3, how to deal with an unrepresented person. In dealing on behalf of a client with a person who is not represented by a counsel, the lawyer shall not state or imply that the lawyer is disinterested. When the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the contract, the lawyer shall make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than recommend that that unrepresented person get their own attorney. If the lawyer knows or should know that the interests of the person have a reasonable possibility of being in conflict with the interests of the client. So if the lawyer and the client um, have a conflict of interest, possibly due to some financial issue in the contractual agreement, the lawyer should recommend to the unrepresented person that they go hire their own attorney. So the question for you in the Module 3 discussion is, what does Rule 4-3 require Joe to do in our scenario involving the purchase of the boat? You'll also need to look at ABA Rule 1.8, the Conflict of Interest Rule. A lawyer shall not enter into a business transaction with a client, knowingly acquire an ownership interest or security or pecuniary interest adverse to the client, unless the transaction, the terms of which the lawyer acquires an interest are fair and reasonable to the client, and must be fully disclosed and transmitted in writing in a manner that can reasonably be understood by the client. The client must be advised in writing of the desirability of seeking and given a reasonable opportunity to seek the advice of independent legal counsel on the transaction where the lawyer may have some kind of financial interest. The client then must give her informed consent in writing, signed, to the essential terms of the transaction and a knowledge of the lawyer's role in the transaction, including whether the lawyer is indeed representing the client in the transaction. So again, in our scenario involving Joe and the purchase of the boat, Joe must comply with ABA Rule 1.8. A lawyer shall not acquire proprietary interest in the case or the subject matter of the litigation the lawyer is conducting for a client, except the lawyer may acquire a lien authorized by law to secure the lawyer's attorney's fees and expenses, or contract with a client for a reasonable contingency fee in a civil case. Those are the only times when a lawyer can acquire proprietary interest in the subject matter of litigation. So the question for you in the Module 3 discussion is, what does Rule 1.8 require Joe to do? And is there truly a conflict of interest in this transaction to purchase the boat? So again, you have your first multiple choice quiz this week. You only have an hour to do it. I would recommend that you review the subject matter of modules 1 and 2 before you take the quiz. And of course, be sure to attend the Module 3 live session where I will give the quiz review. Be sure that you have seen the quiz review before you take the quiz. And hopefully I will see all of you in the Module 3 live session on Wednesday at 6 p.m. Have a great week.